Hello, and welcome to an Outdoor Summit Series presentation focused on a topic we constantly see in the news, privacy and data security. It seems like we hardly go a day without hearing about another breach, ransomware, or scandal involving privacy. And while the headlines tend to focus on the mega breaches hitting the biggest companies, the reality is that most data incidents and regulatory investigations involve small companies, often relating to employee data. So even if you're a startup that doesn't collect consumer personal information, privacy and data security still matters. So today, we're going to give an overview of the legal landscape with an eye towards how these laws apply to and impact the outdoor industry. And we'll also give some practical advice on how to protect yourself from malicious actors and accidental losses, and how to take some basic steps that can keep you out of the litigation and regulatory crosshairs. But first, so you aren't listening to complete strangers, I'll tell you a little bit about who we are. My name is Greg Sevchek, and I'm a privacy and data security partner at the national law firm of Ballard Spahr. I split my time between the Denver and Boulder offices, although I'm also frequently in Utah to help my clients located there. My practice spans from general data compliance issues to advising on mergers and acquisitions to breach response and litigation, and virtually everything in between. A lot of my clients are in the outdoor sports industries or resort industries, both because of the fact that I'm in the Mountain West and because I spend most of my free time in the outdoors. Joining me today is my colleague, Mo Khan. Mo also advises companies on privacy and cybersecurity matters. In particular, Mo works with companies to ensure that they're compliant with various domestic and international privacy and cybersecurity statutes and regulations. In addition, Mo works with companies to assess their privacy and cybersecurity programs, and in doing so, advises companies on various policies, including, but not limited to, company privacy policies, incident response plans, written information security policies, business continuity plans, and document retention programs. Mo has assisted companies and responded to data breach incidents as well. He also regularly provides privacy and cybersecurity related deal advice to companies in connection with mergers, acquisitions, and investment funding. Before we dig into the real substance, I want to get some basic terminology down. Now, these terms are often conflated in the news and even by lawyers who practice in the field, and there is some overlap between these three concepts, but they do have different meanings and different laws govern each of them. We'll drill down the specifics more, but at a high level, data security refers to how you protect the personal information you have. Breach response is what you do when that information has been compromised or lost, and privacy is how you use or share the information that you have. So with that in mind, I'll turn it over to Mo to talk about breach response.
Thanks, Greg. As indicated by that chart that Greg had on the previous slide, breach response is a good area to start at because it has intersection between security as well as privacy. Greg, if you could go to the next slide. All 50 states and many international jurisdictions, including Canada and countries in the EU, have breach response and notification laws. These laws impose certain disclosure obligations on companies in the event that they suffer from a data breach. Under these laws, companies have to notify affected individuals whose data was compromised. And depending on the size of the breach, they may also have to inform regulatory authorities. So these laws generally apply when there's unauthorized access or disclosure of personally identifiable information. This means these laws don't just apply when there's a malicious actor who hacks into a company's system. Instead, they also apply to unauthorized access and disclosure of this information. So these laws can apply, for example, if an employee accesses personal identifiable information that's not necessary for their job and discloses that information, or if a company accidentally posts personally identifiable information online. So what exactly is personally identifiable information? Well, it mostly includes sensitive information, for example, social security numbers, passport information, driver's license numbers, credit card information. The exact definition is dependent on the statute at issue, but it's important to note that the legal landscape around this area is always changing, and it's changing in the direction of protection for individuals. So we could see a broadening definition of personally identifiable information in the future. It's also important to note that when a breach occurs, there are usually tight deadlines in which notifications to customers have to go out. And these, again, will depend on the particular state where the affected individuals are. As Greg mentioned at the top of this presentation, a lot of what we see is employee data that's compromised, not necessarily customer data. And for that reason, breach response and breach notification is becoming increasingly important, not just for bigger companies, but companies of all sizes, including outdoor companies. And Greg, you can take it to the next slide.
Thanks, Mo. Moving on to data security. As I mentioned earlier, and as the name suggests, data security laws regulate what you have to do to protect personally identifiable information that you collect. About half of the states in the United States have some form of generally applicable data security law that places obligations on businesses that collect personally identifiable information from their residents. So as Mo mentioned with the breach notification laws, these data security laws are triggered based on whose information you collect, not where you physically operate. So if you're a retailer in Moab, you might still be subject to Colorado's data security law if your customers are coming in from Colorado. With these data security laws, we're generally talking about what most people would consider sensitive information. So social security numbers, financial account information, government IDs, things like that. There's not 100% overlap with the breach notification laws, but it's a similar concept as to what types of personally identifiable information trigger these laws. But like with breach notification, states are constantly amending these laws. And the trend is almost always to incorporate broader definitions of PII. So everyone needs to stay on top of these laws to make sure that even if they're not subject for what they're collecting now, they won't be next year. And it changes per year how frequently we see these laws coming into play, but we frequently do see a handful of states considering some form of amendment to broaden the definition of PII. Now, two important notes that I think are worth highlighting right now. First, engaging a third-party vendor does not get you off the hook for complying with these laws. So for example, if you're an outdoor sports retailer that operates only online and you use Stripe or another processor to process your payments from the site, and then you would never physically touch the PII because that third-party processor is doing it. But these data security laws would still apply to you as the controller or the business, as they term them. Your compliance regime might be different than if you were directly processing and storing this sensitive information, but you still do have legal obligations to comply, and you're going to want to make sure that you're documenting that compliance. The other thing that I want to point out is, like breach notification, employee information is treated the same as consumer information. So even if you're in a B2B industry, even if you're not collecting consumer information, if you have employees that are in states with these laws, you're still subject to the data security laws. And so you're still going to have obligations to take steps to protect that employee data, whether it be in the form of W-2s or whether it's related to benefit information. You're likely going to have compliance obligations. And again, you're going to want to document your compliance. So what do you have to do if these laws apply? Well, the answer depends. Most states require businesses to take, quote, reasonable information security measures, but they don't define what that means. There is a growing consensus on some basic foundational components of what need to be done to implement a reasonable information security program, but a lot of it does depend on the nature of the business and what PII is being collected. Some other states or industry practices, like the Massachusetts statute, require specific steps. And so your program has to be in writing and you have to have specific components if you collect PII from a Massachusetts resident. Now, it would get a little too granular to get into how to comply with that law in this program, but it is worth saying it is going to be essentially similar to what we would recommend for most general reasonable information security programs. There's just going to be specific statutory obligations to have these specific components. I also want to note that specific industries or activities may trigger other specific requirements. And what we're talking about there is if you're in the healthcare industry, if you're in the financial services industry, if you're collecting credit card or processing credit card payments, you may have additional requirements under those industries and on top of what you're doing for general state data security laws. So, I know this all seems like a heavy lift, but it doesn't have to be quite as burdensome as it seems at first blush. I mean, the first step is really figure out which laws comply. And then you can start figuring out your compliance regime after that. A lot of times getting some outside help does really aid in implementing a compliance regime, but we'll go over some of that foundational stuff at the end. And with that, I'm going to turn it over to Mo to talk about privacy laws.
Privacy is an interesting kind of intersection between data security and breach response. Privacy is more focused on consumer protection. And Greg, if you could go to the next slide for me. There are only a handful of United States that have comprehensive privacy laws. And in particular, those are California, Colorado, and Virginia. There are also international privacy laws that protect consumer privacy or are intended to protect consumer privacy. And the main one that is most often talked about is the GDPR, which is a European law to protect privacy of individuals in Europe. The important thing to note about these privacy laws is they're different than the security laws in scope. And they're different in a couple of ways. And one particular way that they are different is the definition of personal information and how they apply. And this is a way in which these privacy laws are actually broader than security laws. So as Greg and I mentioned before, security laws apply to personally identifiable information, which is things like driver's license, social security number, passport, more sensitive types of information. Privacy laws are meant to protect virtually everything that identifies a consumer. And the way these laws work is they impose certain obligations on businesses to make disclosures to consumers, as well as provide consumers with certain rights. And there are other privacy laws that apply other than the California, Colorado, Virginia, and GDPR laws that I mentioned that are kind of narrower in scope in that they are intended to protect privacy in a certain sector, or type of information. One that we commonly see that Greg will talk about later is biometric data, where there are certain states, Illinois in particular, that has passed a law that covers biometric information. But at a very high level, when looking at these laws, they're going to impose obligations on businesses. And where most of these obligations are going to end up being are changes in privacy policies, as well as the choices that businesses offer consumers with respect to what businesses do with their personal information that they collect from consumers. And another emerging area that we're seeing privacy regulation on is targeted advertising. And that's a constantly changing scope of area of law. Particularly in California, we're seeing the California Attorney General take specific stances on what is considered a sale of personal information and the obligations that arise under whether certain targeted advertising actually consists of a sale. So Greg, could you go to the next slide? When looking at the California, Colorado, and Virginia privacy laws in particular, California's law is in effect right now. It's called the CCPA, and then soon in 2022, it will be replaced with the CPRA, which also includes similar privacy protections for consumers. But at a very broad level, these laws all provide consumer rights related to personal data that's collected by business. And when I say consumer rights, what I mean is consumers will have rights that allow them to request businesses to delete certain data that's collected, gather information from businesses on what types of data are collected, and businesses are going to have to be required to respond to those requests. These obligations on businesses will require disclosures in the privacy policies, as I've mentioned. And then some of the laws, Colorado in particular, will require businesses to do a sort of data protection assessment, which is essentially the privacy version of a cybersecurity risk assessment. And it will assess privacy risks associated with data collected. But something that's important to note with all of these laws, they're consumer protection laws, but they don't include a private right of action. And that's something that's different from the from privacy laws and as compared to breach notification or securities laws. These laws are enforced by primarily the attorney generals, although the Colorado law, once it's in effect in 2022, is also enforceable by district attorneys. And it's important for companies to start to understand their obligations under these laws, because it will require some changes in the disclosures they make to consumers. While we're only seeing 3 comprehensive privacy laws in existence right now, we're definitely seeing a trend for more laws to be passed that would impose obligations on businesses to make privacy disclosures. And so being on top of your obligations, particularly with these laws, we believe will help companies be best positioned for the future when other laws inevitably come up that cover privacy issues. And I'm going to turn it over to Greg for the next slide.
Thanks, Mo. One last thing on this slide before we move on. You'll see some asterisks next to the private right of action, and the reason that's up there is for 2 reasons. One, Mo is correct. There's no private right of action today for any of the currently enacted privacy laws. But as Mo just mentioned, we are seeing, this past year, about a dozen states consider privacy laws, and it's probably what we frequently see with these is states try to compete to some degree as to who has the most consumer friendly and most consumer protecting privacy law. And so a lot of us think that it's only a matter of time before we do see a state that passes some privacy law that has a private right of action in it. And when that happens, the litigation floodgates are just going to be open. We're going to see, essentially, we would expect to see some kind of, the equivalent of a patent troll, but in the privacy realm, where people can go around and look at online privacy policies and see if they're compliant or not, and then try to gather some consumers to file a lawsuit. And so even though there's no private right of action now is really the time to get your house in order. The other reason there are some asterisks up there is at the beginning when I had that slide with the Venn diagram, I mentioned how there was overlap in these. And that is, what has happened with the California law that Mo talked about. The California law that's currently in place, the CCPA, is a privacy law, but they also slipped in there a private right of action for data breaches. So under California, there's now a private right of action for data breaches that are the result of not having appropriate data security measures in place. So it's a good example of how, even though these are distinct concepts, sometimes you will have one of the other concepts slipped into a privacy law. And so it's just something to make sure that we're all staying aware of. But moving on to one particular type of privacy law that I want to give some special attention to, biometric identifier laws. These don't apply to all biometric information, just the type that can be used to identify an individual. So think fingerprints, facial recognition, voice prints. These laws require specific types of consents that must be in writing before you collect the biometric identifiers. In the outdoor sports world, I've seen this come into play in facial recognition software that's used for tagging pictures at races or at resorts. We've seen it in retail apps that let people virtually try on gear or do virtual fittings for various types of gear. We've also seen it a lot in the employment context. So, think employees clocking in through fingerprint scanners. Now, 3 states have these types of laws: Texas, Washington, and Illinois. But one in particular has been the focus, and that's Illinois. And the reason Illinois has been the focus is because it provides its residents with the right to bring a lawsuit and affords them statutory damages. So Illinois residents can recover damages without actually suffering any financial harm. Those damages are on a per violation basis. And as you can imagine, they add up quickly at 1,000 to 5,000 for each violation. And to give you an example of how these come into play, last year, Facebook settled a lawsuit brought by Illinois residents related to its tagging feature, which did not previously ask for prior written consent from Illinois residents. Facebook ultimately settled the lawsuit for $650 million. And the damages could even add up more than that, depending on how a pending lawsuit it shakes out, which is currently being decided by a federal court of appeals. At issue in that appeals case is whether per violation is also per individual. So if a single employee, for example, has clocked in 100 times without giving the prior written consent, whether that is 1 violation or 100 violations for that one employee. So obviously we're talking about billions of dollars at stake. And how that turns out, we'll just have to wait and see. But the thing to remember is that if you are collecting or considering collecting biometric identifiers, you really need to make sure you're complying with these laws. They are not, the basic steps for compliance are not that complicated, but they are very technical. So it's not as simple as just having an individual click "I consent" when they're signing up for something. You do need to have some magic words. And like I said earlier, there are some situations where the actual situation itself makes it a little difficult, like the facial recognition software for photos at a race. We have run into logistical issues, but as long as you know that this type of activity is going on, we're usually able to find a way to get that consent in front of the individual before the point of collection to protect the business. Which brings me to kind of like the slide of some high-level takeaways and best practices. And these are both to help you mitigate the risk of either a lawsuit or regulatory enforcement actions, but it's also there to prepare you for a better result if your business grows and you have a funding or investment opportunity, or if you're the target of a potential acquisition. Because as we see over and over when it comes to either a new round of funding or an acquisition or a sale, privacy and data security are an increasingly big part of the diligence and the representations and warranties. And when we can have a company have not just their house in order, but have it be properly documented, it makes the sale process all that much smoother. It also prevents you from having to either give up some money or agree to do certain compliance steps within a tight time period. And so getting these things in order now don't just protect you, they also help build value in your company. So what are we talking about doing here? Now, the first and foremost, you have to know your data. You don't know what laws apply. You don't know where your risks are. You don't know what you're doing right and wrong until you know what you're actually collecting. So, what we advise all of our clients to do as the first step of virtually any exercise is perform a data map or a data inventory. That can be hiring an outside vendor. It could be doing it on your own. It could be having legal help such as Mo and I, assist on the outside. But at the end of the day, what you really need to do is you need to know what data you're collecting, what laws might apply, and how you're using that data. Step 2, and something that's built into all of the laws, the privacy laws that we're seeing, is the concept of data minimization. Don't collect and store what you don't need. Now, this isn't to say that you have to get rid of all data that you have that you aren't actively using at that time, but it goes into the same kind of concept as the data inventory. Know what you have, know how you're using it, and it doesn't just come into play of let's get rid of this because we're not using it anymore. But there could be ways that you could use the data in your possession to, for example, increase your operational efficiencies or something like that. But you need to know what you have, and you need to get rid of or consider paring down what you are not actively using or don't have a reason to use. And then, the third big practice is, or takeaway is, properly document practices in what we would call foundational policies. We talk to clients who, especially when it comes to data security, have great IT people, whether internal or outside, and they're frequently doing a lot of the right things. What we don't always see is a well-documented policy that you could show in the event that you're the subject of a regulatory subpoena, or if you are in the unfortunate position of litigation, or more happily, if you have an investor looking to invest a significant sum of money and they serve you some diligence requests. So something that we always want to do is not just make sure you're doing the right things, but making sure they're documented in the right type of foundational policies. What we're talking about there is having an online privacy policy in terms of use. And while you can go online and look at any number of websites, there are actual laws that specifically require what you have to have in those privacy policies. And they're not all the same. You might be subject to California's general online privacy policy law, but not to the privacy law that Mo talked about earlier. You might also be subject to the European GDPR, which requires different types of disclosures, but it's really just an exercise in making sure that you're making the correct disclosure. The next thing, and another one they have up here, is terms of use. What is the underlying agreement that you are having for anybody who visits your website or uses your services? And this goes a little beyond just data usage, but it does include data usage. These are both documents that are really, like, it might be a statutory requirement for a privacy policy, but it also is there to protect the company. The second bullet, you see WISP, and that stands for Written Information Security Program. As I mentioned earlier, if you're collecting PII from Massachusetts residents, you have a statutory obligation to have this document. Even if you're not, it is starting to become more of a consensus that this type of a policy is just part of implementing reasonable information security programs. The level of detail and the requirements vary, but it will have the same kind of core components to make sure that the organization as a whole is taking the right general steps to protect information. The third bullet here, an incident response plan. What plan do you have in place for if there is a breach or if there is a loss of personal information? I just want to make sure to say that this can't just be a document that is sitting on the shelf. Like so many things, if you're not practicing it, if you're not familiar with it, it might be good to have on paper, but it's a little bit useless in some degrees. So, what we advise clients to do is have an annual tabletop exercise where you spend an hour or two with the right team and you go through a mock exercise of what happens if you get hit with a ransomware. What happens if you find out that an employee emailed out the entire company's W-2s to somebody who had spoofed an email of the CFO. And the final thing up here is a record retention policy. There are certain states like Colorado that require you to have a written record retention policy or a record destruction policy if you have any Colorado resident personal identifiable information. It's not the heaviest lift in the world to have, but it is something that is technically required by statute. And that's just something else that you can have to make sure that you're disposing of personal information correctly. This is really what we had planned for today. I know it's both a lot of information and not enough information. These are very in-depth topics. It's a constantly changing field, both with laws, case laws, practices. If you're interested in staying up to date on what's going on, you can check out our blog at cyberadvisorblog.com. Both Mo and I regularly post along with our colleagues at Ballard Spahr, and so you can keep up to date on the latest happenings. And we try to keep that updated with big events. I also want to just say thank you all for tuning in. If you have any questions or want to go over anything, please feel free to contact us. We are always happy to have an initial consult to try to see if we, if we are the right fit for you, or if we could point you to somebody who might be a better fit. We're not going to charge you to pick up the phone or send an email to us. So please feel free to reach out if you'd like. And with that, thank you all very much for joining us today. And I look forward to talking soon.